Welcome to Constitutional Landmarks. I'm your host, Mark Oppenheimer. I'm an advocate at the Johannesburg Bar, and I've appeared frequently at the Constitutional Court. During Apartheid, a series of atrocities were committed by the National Party government and by the ANC. During the transition period, it was decided that it was important to uncover the truth of these atrocities. A commission was set up, which was chaired by Desmond Tutu. These are his reflections on the commission.
The raison d'etre for this commission is saying we have dealt with our past as effectively as we could. We have not denied it. We have looked the beast in the eye. In exchange for truth, you will get amnesty. In exchange for telling us everything you know about what you want to ask amnesty for, you will get freedom. Because if you don't, the judicial process, we hope, will take its course. To say, let's forget about it. You re-victimize the victim. You say to the victims, what happened in your case either didn't happen or it doesn't matter. There is something therapeutic about telling your story. You are being acknowledged. You are not a cipher. You are someone. And that is something that says the suffering that you underwent was not just something that said poof into the sky. It contributed to the freedom we are now enjoying. People have experienced a catharsis, a healing. It has been an incredible privilege sitting there and listening to people who by rights should be consumed by anger and bitterness and revenge. And you experience their magnanimity, their willingness to forgive.
Not everyone was satisfied that this Truth and Reconciliation Commission would in fact be constitutional. In the Azapo case, a challenge was brought to the TRC on the basis that it excluded civil claims against those that had perpetrated wrongs against people during apartheid. I spoke with Gilbert Marcus about his role in the case.
At roots, the legal issue, which was ultimately decided, was actually a very narrow one, and one which I don't think was necessarily particularly complicated at all. There was much, much more behind it, though, and that was what might be termed a political dissatisfaction with the process of reconciliation, which had been spearheaded by President Mandela in the transition to democracy. And I say that because the challenge was brought by two individuals and one entity. The entity was Azapo, one of the liberation parties, but certainly not one of the big ones. And it was also brought by the widow of the late Steve Biko and by the son of Griffiths and Victoria Mkenge, who had been murdered by apartheid assassination squads. And so these were groupings, particularly the two individuals, who carried a moral force which was enormous. And the extent of the suffering of their families was emblematic of the suffering of apartheid generally. And they came to court and they said, look, we don't agree with this amnesty idea. We have suffered greatly and we think it's unconstitutional that our rights to civil actions against either the perpetrators or the state as the employers shouldn't be taken away. We think these people should be prosecuted. And it was really a full frontal attack on the amnesty process itself. And we know something about how that came about, because it came about as an 11th hour compromise in the CODESA negotiations. Literally an 11th hour compromise, because the nationalists headed by de Klerk were fearful that the security forces and possibly political leaders as well might face Nuremberg type trials. And President Mandela, who was pretty much assured of victory, had no confidence of the loyalty of the security forces in the new South Africa. So an 11th hour compromise was hammered out, and they agreed to what is sometimes called the Postscript to the Constitution. Some people call it the epilogue. Some people call it the postamble. But the whole point is that it was tagged on at the end, because everything else was already in place. And so they adopted this, I'll call it the postscript to the Constitution, which created the framework for amnesty to the security forces and indeed the liberation movements as well. And it's this postscript which speaks of the Constitution being a historic bridge from a past characterized by suffering, injustice, and it's a bridge to a future based upon human rights and peaceful coexistence. And in order to facilitate that transition and the process of reconciliation, Parliament is directed to enact legislation to provide for amnesty, but it was unspecific on the mechanisms by which that was to be achieved. The legislation was ultimately the Promotion of National Unity and Reconciliation Act, which created what we now know as the Truth Commission, but it had 3 committees to deal with various things. It had a Human Rights Violation Committee, which investigated gross violations of human rights during the apartheid era. It had the Amnesty Committees, which were a series of committees to whom people wanting amnesty had to apply in order to obtain amnesty. And it had a Reparations Committee, which was designed to facilitate a process of reparation for those who had been identified as victims of apartheid.
When the court had to balance the conflicting rights that you have on either side, the sense of justice must be done, perpetrators must be punished, and on the other hand, the sense of a national reconciliation, of saying that we have to forge this new nation, that there is a risk that if we air this out in long judicial proceedings, that we will not be able to craft this new nation, that it will die a stillborn death. How does the court manage to deal with those arguments?
The way our Constitution is constructed is that we have a series of fundamental rights, but none of them are absolute. Every right is capable of limitation, provided the limitation is reasonable and justifiable, and it complies with a test which recognizes the appropriateness of limiting rights in particular circumstances. So the attack by the applicants in the Azapo case was that there is a constitutionally entrenched right of access to courts, and it is those courts who are entrusted with the power and the obligation and the responsibility for settling disputes. The envisaged process of amnesty, however, took that process outside of the courts. It, in fact, stripped the courts of those powers, and it said, we are going to conduct what is really an extra-legal process, and we are going to allow amnesty committees to immunize individuals from criminal or civil liability for what would otherwise be very serious crimes, in many instances crimes of murder, which prior to the Constitution would have resulted in the death penalty. So the court was confronted with ultimately a very simple and singular question, and that is, can this deprivation of rights of access to court be justified? And the limitations clause said, save as is provided anywhere else in the Constitution or in the section which deals with limitations, no rights may be limited. So the question was, did the postscript form part of the Constitution? Because if the answer to that was yes, then the answer to the question was a relatively simple one, namely that this process of amnesty is justified by another provision of the Constitution itself. We didn't even have to go to the limitations clause to answer that question. So it was a narrow question. Did the postscript form part of the Constitution itself? Well, there were several members of the court who were acutely aware of this 11th hour deal because they had been involved in the Codesa negotiations. They had been involved in advising the parties. They knew, and this was certainly the target of my argument, that the postscript and the legislation which was enacted to give it effect was the glue which held the Constitution together. It was that deal which was struck to prevent Nuremberg-type trials and to ensure the loyalty of the security forces after the transition. So people like the then Chief Justice, Arthur Chaskelson, had been intimately involved in those negotiations. Johann Krichler was the first chair of the Independent Electoral Commission. He presided over the first elections. Pius Lange was involved in the negotiations, as was Albie Sachs. Ismail Mohammed chaired various sessions of the Codesa talks. They knew beyond a shadow of a doubt to undo the amnesty process would have been a potential threat to the democracy. I think we have to start off with fundamentals, and that is why opponents of the process regard amnesties as inimical to the rule of law. And there is a very, very powerful and perfectly respectable argument which says that for countries in transition, it is better to have prosecutions followed by, for example, presidential pardons than to have a process of amnesty. Now, the South African model was a sort of hybrid. It was not a blanket amnesty, and I'll say something about that in a moment. But the point about it is simply this, that you do damage to the rule of law when people escape prosecution for very, very serious crimes. And the debate really is, how does one ensure ongoing respect for the rule of law in a future democratic order when it's built on a foundation of disrespect for the rule of law? And so there are some pretty powerful arguments opposed to amnesty. The idea was to try and marry the two. So it was not a judicial process which occurred before the amnesty committees, but those committees were presided over by judges. They took place in the open. They all allowed cross-examination and legal representation. So they took the form of mini trials. And there were certain obligations on an applicant for amnesty, the most important of which was that they had to confess guilt. So you couldn't apply for amnesty unless you had either already been found guilty in a court, or if you admitted to guilt if you had not yet been prosecuted. So an admission of guilt was a starting point. I think that was important. But there were other requirements, probably the most important of which was that an applicant seeking amnesty had to disclose the full truth. And there were many instances of applicants for amnesty who failed precisely because the amnesty committee found that they hadn't told the full truth. Perhaps the prime example, or perhaps one of the most well-known examples, were the killers of Chris Hani, Clive Derby-Lewis and Janusz Walusz, who were denied amnesty amongst other reasons because they hadn't disclosed the whole truth. The problem was this, that the atrocities committed under apartheid were so widespread, and there were so many of them, that in the end, not many people applied for amnesty. There were approximately 8,000, I'm rounding off the numbers, approximately 8,000 applications for amnesty, the vast majority of which were not granted. I think the figure was approximately 750 applications were granted. And the idea was that those who had been refused amnesty, or those who had not applied for amnesty, would be prosecuted. And the simple, ugly truth is that that has basically never happened. There has been effectively only one prosecution of which I'm aware, and that was the somewhat tepid prosecution of the former Minister of Law and Order, Adrian Vlok, for the attempted murder of Frank Chikane, for which he got a 10-year suspended sentence. But the reality is that some of the worst perpetrators either didn't apply for amnesty or have never been prosecuted. So that formula of amnesty for truth, I think, has had a limited impact. So that's the first reason why I think the experiment is not the success that many hoped it would be and many proclaim it to in fact have been. There is another reason, and that is that the state has attempted in various somewhat underhand ways to provide a parallel amnesty process, but outside of the Truth Commission, and in ways which have ignored what was intended to be a victim-centric process. So, for example, they some years announced a new prosecutions policy, which vested a discretion in the National Director of Public Prosecutions, a power to decline to prosecute in circumstances basically indistinguishable from the amnesty process. That process required the crime to have been committed with a political motive, and it required full disclosure. They simply attempted to adopt a policy which replicated that process. I was involved in a challenge to that process which succeeded, and that was still born. Then there was an alternative process which was adopted by President Mbeki to enact a policy for granting presidential pardons to those who had been convicted of politically motivated offences. And once again, it failed because it excluded in its entirety the victims of those crimes and sought to exclude them from being heard. So that too failed. And then I suppose lastly is the question of the discovery of the truth. I'm afraid 24 years down the line, we keep on discovering more about the ugly truth. And certainly we learnt a great deal about what was done in the name of apartheid and the atrocities that were committed. But I don't think we know all of it by any stretch of the imagination. So that's why I'm lukewarm about the success of that enterprise, much as I am an enthusiastic supporter of Archbishop Tutu and President Mandela, whom I sincerely believe were the absolute centerpieces of the transition to democracy, and without whom I don't think we would have achieved this. The security forces, I believe, are in possession of information which might be embarrassing to the ANC and possibly even some of its leaders. That was the nature of the dirty war, and there are constantly undertones of threats that things will be exposed. We don't know what they are, but we can guess at what they might be. And so I think that one of the possible drivers of this attempt to do the work of the Truth Commission by different means is to try and suppress that kind of information. I think we have to face the reality that the process of amnesty protected bad deeds on both sides. The Truth Commission has got the great advantage of having annoyed everyone. It annoyed the National Party, who attempted to interdict the publication of their final report days before it was published, and they annoyed the ANC, who attempted unsuccessfully to try for a blanket amnesty on behalf of every member of the ANC, and neither did that work. So that's what compromises are about. It leaves both sides unhappy, and that tends to be the definition of a good settlement. There is perhaps a reluctance in some quarters to expose the whole truth, because I don't think that that's going to be a pretty picture.
If we run a counterfactual, so if instead of having a TRC process, we'd run Nuremberg trials. So, for example, one of my colleagues acted as a prosecutor in Cambodia. Their process has gone on for 13 years. The Khmer Rouge committed untold atrocities against the Cambodian people. 2 million people were killed in a very short period of time. And in their 13-year trial process, there have only been 3 convictions, and a very limited amount of truth has come out. And what a lot of people hunger for is, what happened to my family members? Where are they buried? And it's very hard to get that out of a criminal process, because people have every incentive in the world to protect themselves, to not reveal what happened.
Mark, I think that's a very powerful point, and I think it's very true of the situation in South Africa. There were 2 very high-profile prosecutions with mixed success. The one was the prosecution of Magnus Milan, the former Minister of Defence, and the other was the prosecution of Eugene de Kock. They took years to run, and you're absolutely right. The moment one engages in a criminal process, it takes a great deal of time, a great deal of resources, and there's a big question mark as to how much truth you uncover. Sorry, there was a third prosecution which didn't yield much at all, and that was the prosecution of voter Bason. There were limited prosecutions, there was limited success from those prosecutions, and one wonders how much emerged from those cases. I'm not underestimating the importance of those prosecutions, because they were taking place parallel with the amnesty process, and I suspect that the very fact of those prosecutions and the very fact that they were high-profile prosecutions probably served as an inducement to some people to come forward. It's a question of prolonging the agony. One of the very specific designs of the legislation creating the Truth Commission was that the Truth Commission was intended to have a limited life, and it was not intended to drag out the process for a very, very long period of time. And I think that was in recognition of the kinds of problems that you mentioned in places like Cambodia. There were other issues on the international law plane which simply weren't fully explored. We know, for example, in 1973, the United Nations adopted the International Convention on the Suppression and Prosecution of the Crime of Apartheid. And many of the things that were done in the name of apartheid would have constituted crimes under that convention didn't really feature at all in the amnesty process. And of course, it would have exposed political leaders to prosecution under that convention, assuming it to have been possible. I think we cannot lose sight of the extraordinary footage which we saw night after night on television of torturers coming forward, being asked to reenact what they did to activists. Those left very, very powerful images. I suspect it had more of an impact upon white South Africans than on others, because there were far too many white South Africans who chose to turn a blind eye, and they were suddenly confronted with what had been going on in their names. And I do think that was important going forward. Where I think there are problems, and we see it ongoing every day, is that there's the sense of unfinished business. And Mark, you're absolutely right that some of the requests of the victims of apartheid were completely modest. They were not necessarily looking for the satisfaction of a criminal conviction after a prolonged trial. They simply wanted to know, where are the remains of my loved ones? Or can I have a headstone for the grave? They were incredibly modest and moving requests of a nature which could easily have been met. And I don't think they have been met. And hence there is a sense of unfinished business now. And I think one might have to give some thought as to how in a post-apartheid society these issues can be addressed. I know the churches are looking at it, but we'll have to see.
When you make this compromise and you deny people a right of civil action, and you say, well, you cannot get financial compensation for the murder of your breadwinner, is that the state says, well, what we'll do is compensate you. And you find that, and this is what happened with Germany and Israel. The new non-Nazi German state came in and said, we recognize the wrongs of the past. We recognize that Jews were murdered en masse and stolen from en masse. And we're going to compensate this new state of Israel for a very long period of time. Has our current state done that for the victims of apartheid?
Absolutely not. If there's one aspect of the truth and reconciliation process that I think I could label as a failure, it would be the reparations process. And I think that if I speak of unfinished business, that would be my target, because I think that there is so much more that could be done. And as I say, it's not on a grandiose scale. The requests are in many instances very, very modest. But it's messy. That's the point. It's digging up the past in circumstances where there are people who've got a great deal to hide. And of course, it's getting more and more distant. We've seen recently the reopening of the inquest into the death of Ahmed Timol. Some of the perpetrators, or the alleged perpetrators of his murder, are dead, and we are left with one who's been charged, who I think is in his 80s. These are difficult questions.
You look at the Simon Wiesenthal Center saying that justice must be done and that those Nazis that perpetrated crimes will be found and will be prosecuted regardless of their age, and that's how you come to terms with that injustice. The other thing that's sort of happening at the moment is a sense of skepticism about our constitutional project and about this, what people kind of flippantly refer to as a rainbowism, and that they're rejecting reconciliation, especially young people on campuses, feel that there was a betrayal, that they were sold out by Tutu and sold out by Mandela. What's your response to that?
It's a response which I understand, because the Constitution promised much, and I think that it has not delivered on all those promises. I think that, however, is a relatively simplistic equation. Those like myself who spanned the apartheid and the post-apartheid era, particularly in the legal sphere, I have to remind myself every day how bad it was under apartheid. And I think that younger people who haven't had to live through that experience, quite understandably, don't know how bad it was. So I'm more enthusiastic about the constitutional enterprise and what it has achieved. To say that it hasn't achieved all its promises is to state the obvious. But it was an enterprise that was beset with obstacles from the outset. In the legal work that I do post-apartheid, and from time to time I am asked to act for the government, I see over and over again just how damaging and debilitating apartheid was. And the new government has inherited an overwhelming problem which has infected every single facet of our society. I absolutely accept that much more could have been done and should have been done. I absolutely accept that problems of corruption and inefficiency have set us back. But I can only hope that, these are problems which can be overcome. In many, many spheres, one can point to the extraordinary housing projects undertaken by the Reconstruction and Development Program. One can look at electrification, one can look at the provision of clean water. A great deal has been achieved. Not enough, absolutely.
A new generation forgets that South Africa was on the brink of a civil war, that there was a time when our entire national project could have failed and could have led to mass bloodshed, and we managed to avoid that through careful political maneuvering and through some litigation.
Well, I remember the days preceding and following the 27th of April. There were bombs going off around the country, including at what is now OR Tambo Airport. There were certainly those who were hell-bent on rendering the new democracy stillborn. I spend a lot of my time as an advocate trying to persuade people not to go to court. Sometimes they don't have a choice, but in so persuading them, and very, very often in the sphere of public interest litigation, I think that the courts ought to be recourse of last resort, and that the kinds of problems that we are talking about are best settled or best resolved politically. It's only when the political process fails that I think that legal action is an option to be considered. But I also think we should be very careful in understanding the limits of the legal process. And what we have seen in recent years with the failure of the Zuma presidency and all the problems associated with it is constant recourse to the courts by political parties, amongst others. Again, it's not surprising, and it's not something that I'm necessarily critical of, but it's not something that courts are terribly comfortable with. And I think that we have to recognize that. And we have to recognize that the courts are not the solution to all our ills. More often than not, those solutions are political in nature, but of course, then you have to have the political will.
Is there a sense in which courts have to play a greater role when the other portions of government are failing? So when you have a corrupt executive or an inactive legislature, that courts then are required to, take up that responsibility and maybe intrude into areas where they would not have otherwise?
I think that that's a fair comment, because the problems arise typically in moments of crisis. And I certainly would characterize the latter years of the Zuma regime as as a series of crises, the courts have stepped in to redress to the extent possible some of those problems. I don't think that that detracts from the fact that there is a discomfort in courts when that happens, but I think we have a great deal to be grateful in the record of the courts in the past few years in very, very courageously standing up in a very, very hostile political climate. There are some terribly nasty examples of attacks on NGOs merely because they've gone to court to try and vindicate the rule of law. And that is the kind of response that one sees in authoritarian regimes, is they turn on the players and they turn on the courts. And there have been very serious tensions between the courts and the executive, culminating in 2016 in a very high-level meeting between the heads of court and the executive because of what the politicians perceive to be an impermissible crossing the line of the separation of powers. Now, all governments tend to resent court decisions which go against them, but it's a very, very different matter when the political leaders at the highest level start denigrating the courts. That's when you start having the beginnings of a potential constitutional crisis. I think we've averted that.
Justice Albie Sachs was one of the first judges to have been appointed to the Constitutional Court. He was present during the hearing of the matter and signed on to the majority judgment. It was a case with much significance for Albie. He had spent much of his time during apartheid living in exile. While he was in Mozambique, a bomb was planted in his car. He survived the blast, but he lost an eye and one arm. He later went on to write the book, The Soft Vengeance of a Freedom Fighter.
I remember when we got photocopies of the judgment written by Ismail Mohammed. I read the judgment. I ran to Ismail's chambers. I knocked on the door. I said, Ismail, it's a beautiful judgment. Thank you for writing it. He was like astonished, embarrassed, awkward. This was a case that doesn't turn on the meaning of this word or that word. It's a case that deals with pain, deep human pain. It deals with atrocity. It deals with finding ways to reconcile the needs of the future and moving ahead with generosity, bringing everybody in with acknowledgement of the pain of the past. And it required a certain tone of language, a style of presentation. And Ismail, who had a capacity to use language that none of us could reach and express legal thoughts in ways that were lyrical and profound and deep, I found he had done that. In our workshops, of course, colleagues were very interested to know how would Albie react. I had supported the TRC process from the beginning. That's part of soft vengeance. It's getting people to come forward and acknowledge what they've done is so important for healing, so profoundly important. It's not just that it has huge pragmatic value. The cases go on forever and ever. You choose some people, you get the accomplices to testify against them, and you give them amnesty. Their appeals, our courts are clogged up anyhow. The pain extends into the future, and you get so little truth in court trials anyhow. Now we could get the truth to come pouring out, and we could hear everybody. I just felt, in that sense, very, very enthusiastic about the process. Not that that was going to make South Africa a just, fair, equal society. That wasn't the role of the TRC. But exceptionally painful and exceptionally awful and atrocious things could be revealed, and the secrecy could be destroyed. Colleagues could see that Albie was supportive of the whole kind of a process and felt on balance that Parliament had the right to do what it had done. And you might find some of my own particular arguments that I used found their way into the judgment. I can spot here and there. But the basic conceptualization was Ishmael's. He didn't even say this is the best way to go. He just said that's an area of discretion that the Constitution gives to Parliament. And we can't say that Parliament exercised the discretion in a way that was unconstitutional. It's very, very cautious. But the way he poised his indignation about the atrocious crimes of the past, putting it out there on the page so sharply and clearly, with what he calls the agonizing decision of how best to respond, I just thought was exquisite. For me, this is one of the world's great judgments. One of the world's great judgments. The call for the Truth Commission came initially from the National Executive Committee of the ANC, dealing with gross violations of rights by ANC camp officials against captured enemy agents. A commission had been set up by the ANC. This was before we had our first democratic elections, which had reported strong prima facie evidence of these violations, calling for a response by the ANC, and the ANC cut us saying we need a truth commission. The outcome was that provision that met up with the claims of the generals and the others who had protected the democratic process, who didn't want to go to jail afterwards, while de Klerk and the others would be fine. So we combined the ANC requirement of having a truth commission with the possibility of amnesty for the generals, but we made it conditional on them coming forward to tell the truth. That was a South African remedy, if you like, response, very specific thing. That was part of the historic background. I don't think Ishmael knew that. He just had the text of the Constitution before him. There had to be amnesty, but Parliament could work out the conditions. That provided the foundation. And then Ishmael you needed a sense of history. You needed a sense of understanding the deep hurt that was not simply produced by the tortures and the violations. It was the whole oppressive racist system of domination, dispossession. All of that was there. That's all part of the background, but most powerfully exemplified by the disrespect for the human person through torture. It was overwhelmingly whites torturing blacks, or maybe blacks torturing blacks, but urged on by whites to do that. It had a colonial racist dimension to it all the way through. And Ishmael intuited that, he understood that, and he found glorious language to capture the importance of acknowledging, recognizing that deep, deep, deep pain and the viciousness of it on the one hand, and the importance of a magnanimity that presupposed people coming forward and telling the truth. And I felt he just got that poise in exquisite language. And that's why I ran over to his chambers to congratulate him. I think the Truth Commission was extraordinarily successful. People now critique it because they feel their lives haven't changed enough, that whites are still lauding it in all sorts of ways and taking it for granted and don't even have the insight into the extent to which the privileges they take for granted as normal were built on, rooted in the dispossession and the injustice of the past. And so now the critique is a kind of retroactive critique based on present disappointment. But that wasn't the fault of the Truth Commission. The Truth Commission had enormous impact throughout the world. As an example, it was seen as of reconciliation and so on. It was much deeper than that. It was the willingness of people to come forward and acknowledge what they'd done. It was the willingness to listen to the testimony of those who'd suffered, but in a very focused area. It wasn't land dispossession. It wasn't disenfranchisement. It wasn't sitting on separate seats. It was what was unlawful under the old law, the assassinations, the tortures, the violence, and so on, focusing just on that, but as a symbolization of what was most atrocious in the old system. And in that sense, what people remember is not the report. Nobody reads the report. They remember the testimony. They remember hearing it on the radio, reading about it in the newspapers, being forced to confront, where were we? What was I doing? How can we prevent these things from happening in future? As one American political scientist said, it's converting knowledge into acknowledgement. And in that sense, I think it was hugely successful. It was successful in the sense that there were people in charge like Tutu and others who, they weren't neutral. You can't be neutral on violence and torture. But they were impartial. They listened to everybody. It was an extraordinary example of an institutionalization of a mechanism that was open to that extent, of being able to contain the extreme emotions and passions in a way that you didn't feel these are show trials, this is a setup, this is done for TV. To my mind, the Truth Commission didn't just capture the truth, you can never capture truth, of our history. It became part of our history, a very important part of our history. If we hadn't had that, all the complaints we have today of inequality and injustice would have been worse. If we had gone for trials, I think the outcomes also would have been worse. We had a couple of trials of generals and others. They got nowhere. Getting the evidence was difficult. They took ages. Dr. Death, as he was called, put on trial in the end. No successful prosecution. Magnus, Milan, long trial. Many people surprised by the outcome, no conviction. So it wasn't as though there was a viable alternative. Understandable, critiquing the Truth Commission because of today's discontent and disappointments. But I feel that it's an unfair critique. I feel overwhelmingly the Truth Commission played a huge role in our country that was very, very positive, very profound, very, very meaningful, that we all benefited from it. And that the world can learn a lot from. But did the Truth Commission create a fair, just, equal society? The answer is no, but that wasn't its role.
I hope you enjoyed this episode of Constitutional Landmarks. Throughout this series, I'm going to be interviewing some of the greatest advocates that have ever appeared in the Constitutional Court. I will also be speaking to the judges who authored the court's landmark decisions. We'll be speaking about gay marriage, free speech, and a range of other exciting issues.